When former in-house defense attorney Dimitrios Biller resigned from his top post at Toyota, he walked out with something potentially more valuable than his severance package. He took some 6,000 internal documents, including memos and emails, that could be potentially damaging to his former employer. My guest is Dimitrios Biller, an attorney in Pacific Palisades, California. Dimitrios, thanks for talking with us today.
Well, thank you for having me.
Why did you leave Toyota at that time? It sounds like they were compensating you pretty well and keeping you pretty busy.
Under the California rules of professional conduct, I had to leave and voluntarily resign because Toyota was concealing and destroying evidence. And as a lawyer, I cannot represent a client who has retained me for the purposes of committing criminal or fraudulent acts.
So you're involved in litigation right now with Toyota. You defended the company in product liability and negligence cases for about 4 years?
4.5 years.
Okay. And you left the company simply because you thought they were committing criminal acts?
Oh, I was ethically bound to leave the company because they retained me for the purpose of helping them commit criminal acts, and I wasn't going to do that.
What kinds of things are we talking about here?
Concealment of evidence, destruction of evidence, perjury, mail and wire fraud, obstruction of justice, and conspiracy to commit all those crimes.
So what kinds of evidence then are we talking about? What were they trying to conceal?
They were trying to conceal the important type of documents that would be helpful to the plaintiff's bar in prosecuting either a negligence claim or a product liability claim arising from a car accident involving a Toyota vehicle.
Did you come across documents that pertain to what they're dealing with right now, the acceleration problems, the braking problems, things like that?
Yes, I handled a class action involving sudden acceleration in 2005.
It sounds to me that even though this seems like a fairly recent thing that's become known, that these types of problems were happening, as long as 5-6 years ago, but Toyota had been covering them up.
Toyota's conspiracy about concealing evidence, violating court orders, not producing the evidence it was obligated to produce, goes back 35 years.
Can you talk about some of the cases that you defended Toyota in?
Sure. I'll focus on the cases that led me to my resignation.
Okay.
Obviously, there was the Sears case. Sears was Toyota involving a 2001 Avalon that arose out of a two-car accident in which the vehicle rolled over and the right front passenger's head went out the side of the window and was crushed between the ground and the roof. The plaintiffs brought a lawsuit against Toyota claiming numerous safety defect allegations related to roof strength and roof structure, glazing, in other words, glass, seatbelt pretensioners, rollover resistance, and side airbag curtains. Mm-hmm. Because the case was rather significant, I then started my own investigation to get information I believe the plaintiffs would request in the ordinary course of business. And that investigation took me to what was known back then as Toyota Technical Center. It is now known as Toyota Engineering and Manufacturing North America, Inc. In a 1-year-long investigation, I collected what are known as books of knowledge and both electronic form and paper form. Mm-hmm. I also had collected, I learned about some significant computer systems that exist that had never been revealed to me. Mm-hmm. And we made a sweep of the information documents we thought were potentially relevant. Mm-hmm. The next step to that process was to review the documents. Our boss told me not to. Mm-hmm. He ordered me not to review the documents.
So the people at Toyota are saying that you're making just overall inaccurate, misleading statements, and they strongly dispute what you're saying, probably not a surprise to you.
No, it's not a surprise to me, but has Toyota ever come out with any fact or document to prove my statements are misleading or inaccurate? They've never done that because my statements are not. And they've only given those statements, and they're empty statements, because they know they cannot prove that I'm being inaccurate or misleading.
Did they, during your time with Toyota, did they, do you think, ask you to do illegal things?
Absolutely. They prevented me from conducting investigations at places like Toyota Motor North America, Inc., and at TEMA in Ann Arbor. They prevented me from obtaining information from resources that nobody ever had tapped into. I was very aggressive in the manner in which I defended the cases in terms of collecting evidence and wanting to produce the evidence. But Toyota doesn't want a level playing field when it takes cases to trial. It wants to have an advantage, and it wants to put the plaintiffs at a disadvantage.
It says that during your time there as well, that because of all the stress you were under, that you actually had a nervous breakdown at one point.
Well, what happened was in October of '05, I learned that my boss was going to prevent me from reviewing the documents after a year-long search and investigation. I started to have anxiety, stress, frustration, and an early onset of depression. As '05 passed into '06 and into '07, by the time in May of '07, I was diagnosed with major depressive disorder.
So after leaving Toyota, they compensated you pretty well. I think it was somewhere in the neighborhood of $4 million was your severance package, which that's a nice little severance package. Is it difficult for you after being compensated so well to actually turn on them in this way?
Not at all.
Okay.
They didn't compensate me because I was ill or because they made me ill. They gave me that money to shut me up. It was hush money. That's what it was. And I signed a severance agreement containing a confidentiality clause in which they have used in an illegal manner. According to Toyota, I can never tell anybody I worked for Toyota. I can't tell anybody what I did for Toyota. I have to eliminate 5 years of my life from my resume because I can't even refer to Toyota as an employer. That's not what the confidentiality agreement requires. They've used it in an illegal manner.
Most people's impressions, finally, of the company Toyota itself, and I have up until now, I've been one of them, has that the company is run extremely well. It's one of the few profitable automobile companies in the world. They make a fantastic product. From what you're saying, though, it sounds like this has been a top-to-bottom kind of concealment of evidence, that everybody's sort of involved here, or is it this just sort of one department of Toyota?
No, I think it's a multi-company conspiracy. Obviously, Toyota in Japan, legal department and engineering divisions are involved in the conspiracy because the engineering divisions are the people who are responsible for gathering up evidence to respond to discovery. Obviously, Toyota Motor Sales USA Inc. in Torrance is involved because my boss, Eric Tyra, did not make any demands of the in-house counsel to look for the evidence, and he merely relied on what Toyota in Japan was giving us. There were no investigations of the North America affiliates at TEMA or TMA, but there were people within those two companies that engaged and agreed with the conspiracy to conceal and destroy evidence. Chris Tinto, for example, in TMA in Washington, had an agreement with Eric Tyra to conceal and to destroy evidence.
Well, Dimitrios, we appreciate your time. I guess we cannot wait to see those documents. And I thank you for talking with us, and I wish you good luck, sir.
Thank you very much.
Once again, my guest is former in-house defense counsel Dimitrios Biller. He left Toyota a few years ago, taking with him over 6,000 documents that sound fairly incriminating. You're watching the Legal Broadcast Network.